So here's a problem or issue, often with your traditional broker relationship for probate investing, and that is that there is no real standard or conflict of interest protection for regular clients. I mean, how many of you have this conversation with your advisor? Hey, Terry, I want you to sell Apple and buy IBM because Apple stinks now and IBM's the greatest thing since sliced bread, and I'm going to get a 2 or 3% commission in the middle of that. That is not in the client's best interest. What we need to do for your clients who might be a 6-year-old in a wheelchair or an adult disabled person or grandma with dementia is make sure that their money lasts throughout their lifetime with prudent investing that gets a reasonable return with low risk. This is just one example of $128,000 of churning commissions that happened for a client in New York as an example of what can happen when you're under what they call the suitability standard rather than the fiduciary standard of investment. So recently, there has been some changes in the law and the regulations. So back in 2008 and 9, with anybody heard of a guy named Madoff, Bernie Madoff? So he was a registered investment advisor who was supposed to follow a fiduciary standard, but instead he was fraudulent. And that's one of the worst examples, but some of the more insidious hidden examples are just high commissions, undisclosed items, conflict of interest of what you ought to buy and not buy. And if you have a trust relationship with an advisor or broker, how do you know that they're acting in your best interest or not? So out of the 2008 and 9 situation, some items resulted that changed the regulations. We're going to talk about that real quick. So the two ways that you can have a basis with your broker, investment advisor, management consultant, whatever you want to call them, insurance agent, et cetera, are either the suitability standard or the fiduciary standard. The suitability standard is a very low bar of compliance, which is it just has to be suitable for the client. So if the client's wealthy and old, you can justify that you might buy some weird foreign security or to buy a annuity with 15% commission and 15-year surrender period where they have to pay back in fees. You might be able to justify that under the suitability standard, but not under the fiduciary standard, because the fiduciary standard requires you to put the client's best interest first by law, to be a fiduciary, a legal fiduciary on the account, and to avoid material conflict of interest, as well as not charge unreasonable fees. So I would have you all take inventory of your own relationship with brokers or financial advisors or insurance agents on what standard do you have and do you know what it is? So 2 questions, if you learn nothing more from this seminar presentation, it is these. Number 1 is ask your advisor, broker, whatever, are you a fiduciary on this account and will you put that in writing? And number 2, what is the total all-in fee that you're charging me, including internal costs of investments that might be hidden from me? Those 2 questions. That bears repeating. Are you a fiduciary on this account or not, and will you put that in writing? And if they're not, you might reconsider. Number 2 is, what is the total all-in fee? Not just your advertised fee, but the cost of trading costs, et cetera, inside the items that you're selling me. And they ought to do that in big red letters in the contract. The SEC should require that, in my opinion, but they don't. And here is why. So the government, after the Obama government, et cetera, when they set up the Consumer Financial Protection Bureau, tried to put in a fiduciary standard of investment requirement on all brokers, advisors, insurance agents, et cetera, and they could not get that through a divided Congress and had a lot of pushback from people who were being enriched by giving biased advice. So they started that system called the fiduciary rule, but it was vacated by the Ninth Circuit Court after the Trump administration came in. And instead, we have the newest item that's going to come into play called the SEC investor protection rule called Regulation Best Interest, or RBI. So the problem with this is it requires that brokers cannot have a conflict of interest, but they must just disclose the conflict. And that's where the rub is. So unless you ask those two important questions, you're not going to know what you're getting. And remember, it has to be in the contract. So you attorneys that are estate planning or elder law attorneys out there should be cautioning your families, your trustee family members, your conservators, et cetera, to find out what standard they're under and what is the fee rate you're paying in order to avoid problems. Almost all of the issues come because somebody's getting paid money that they shouldn't, or items are complicated on purpose to enrich the selling agency. So Scott and Paul's rule number 1 is, for investing, if you can't understand it in 30 seconds, don't buy it. Somebody's getting over on you. I can understand owning this Apple computer and getting my share of that profit and the dividends. But what is a collateralized mortgage obligation bond with 17 tranches of different risk level? Who understands that? Who saw The Big Short? Well, that's exactly, nobody would have gotten in trouble with that if you'd have used Scott and Paul's rule number 1, which is it's too complicated, I'm not buying that junk, right? But I can understand being an owner of Procter & Gamble and selling Tide and Love's diapers all over the world. Yeah, I get that. I'm the owner. But all that other stuff, derivatives, et cetera, they haven't usually worked out for clients. Simplify, cut the costs, and do quality investing, and you're generally going to do better if given enough time. So what happens with suitability standard type account? Well, the real issue is lots of expenses and fees. Paul, you want to cover that?
Absolutely. So, this is a perfect example right here of an investment firm that did not uphold the fiduciary standard. They really took in the money to manage it and to basically enrich the firm itself, and they didn't really do right by the beneficiary by making distributions, by getting the money out needed for the actual care, and they were to be found held liable for their inability to actually do what's in the best interest of the client. And so as you look through these examples, every day you're going to find a new example of how somebody's been taken advantage of. And back to Scott's point originally, it really comes down to understanding the relationship you have with your advisor. And we have found so many times that is a key portion of the conversation that somehow gets overlooked or is at least skirted by because the details were not disclosed.
So this is an example of actual language in a contract that has a suitability standard. Notice it says they are not acting as a fiduciary or investment advisor under the Act, right? So there it is. So what you sign in your contract is what matters. Now you might have somebody say, oh, we're a fee-based only financial planner. But that's not enough. The contract has to say which standard they are under. This is an example in yellow of an item that says that they are acting as a fiduciary, right? So as an advisor, they have to have no conflict of interest, et cetera. If you want these materials, they're available from your bar association, so you can see example of the language.
Yeah, and you'll find a lot of times that language is perhaps not necessarily missing, but never even disclosed. And without having the opportunity to look through the contract, people sign without understanding what they're actually signing. I'm sure we've never seen that before, right? And then only after when something goes wrong, then the question becomes, well, what standard were you operating on?
What happened? And of course, so if there's not a fiduciary advisory relationship, then the firm and the advisor broker are going to run for cover underneath that, right? Whereas if it's an advisory relationship of this type, then you also are getting duty to defend. So you're going to get your client, your beneficiary, that might be that 6-year-old kid in a wheelchair, is not only going to have a firm not back away from it, but they have a duty to defend that relationship with that client. So if you have a conservator or trustee, for example, that's professional or family member, we have to bring the army of lawyers from Merrill Lynch involved to defend them against malfeasance questions or other items in court, because we are on the same side of the table as them.
So when you're looking at the advisory relationship, the previous slide had mentioned a couple things to look for. A lot of times disclosure gets kind of eaten up in the amount of materials that are handed to you. How many times did you go to the mailbox for your investment firm and they've sent you the thickest prospectus you've ever seen, which is really, really good for holding up the table leg for the, in the kitchen. We have found that is one of the biggest problems we have in this industry is over disclosure, not simplification.